Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. أسعد الله أوقاتكم بالخير مستمعين في كل مكان، ونرحب بكم في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز. وهذا البرنامج اليومي الذي يقدم لكم العديد من المعلومات القيمة في مختلف القضايا والاختصاصات القانونية التي يتعامل معها مكتب المحامية جومانا كيروز، وهي قضايا الإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، وأيضا قضايا الهجرة والتجنس، قضايا الإفلاس، وقضايا الضمان الاجتماعي، قوانين العائلة والكريمنال لو. أيضا بإمكانكم المشاركة في هذا البرنامج يوميا على الأرقام 313-769-6666 519-256-1023 وعبر الواتساب برسائل صوتية أو نصية 313-327-7074. بإمكانكم الحصول أيضا على استشارات مجانية بهذه الاختصاصات التي ذكرناها 248-557-3645. رقم المكتب مكتب المحامي جومانا كيروز 248-557-3645. تحياتنا لكم. جومانا مساء الخير.
صباح الخير، يعطيك
الله يعافيك، يا أهلا وسهلا، نرحب بيكي جومانا.
مساء الخير لك لضيف مثل نهار خميس المحامي باتريك. Pat, can you hear us?
Yes, I can hear you.
Okay. رامي بعد عن شيء بالصوت.
للأسف في شوية تقطعات جومانا بصوتك، يمكن أيضا لو شوية تحولين مكانك إلى مكان آخر حتى يمكن يساعد هذا الشيء شوية.
نعم، وأنا أتكلم معك في مكان آخر. والله يا رب.
تفضلي جومانا. نعم.
أوكي، كم صباح الخير. مثل كل نهار خميس صرنا عم نحكي على قانون السوشيال سيكيورتي، يعني الضمان الاجتماعي والإصابات ضمن العمل، يعني الوركمنز كومبنسيشن. المحامي باتريك هوران انضم لمكتبنا، عنده خبرة تقريبا 28 سنة 27 سنة شوي، وعم نستفيد كثير من خبرته ونشكره على هذا الموضوع. اليوم رح نبدأ بالإصابات ضمن العمل، وبعدين عم ننتقل إذا الوقت سمح لنقطة بتخص السوشيال سيكيورتي وبالتحديد SSI for Children. نوضح بعض الأمور بهذا الموضوع إذا الوقت سمح
إن شاء الله.
Attorney Patrick Horan, how are you today?
I am fine, Joumana. How are you today?
Very good, very good. I apologize. I tried to switch places 3 times now, and it's a little bit better, but not much better. You hear a lot of static?
There is a little bit of an echo.
Yes, I do apologize about that. Unfortunately, I cannot put this on my ears because I will not be able to see if we got a question or if we got a caller or anything. Patrick, we wanted to begin by talking about workmen's compensation issues. Very particularly today, we wanted to talk about someone who may have been injured on the job and has already opened a claim with the Workmen's Compensation Bureau, starting her or his treatment. The first point we want to make is that the laws in Workmen's Compensation say that for the first 28 days, it used to be the first 10 days. Very sadly, it became the first 28 continuous days after your work-related injury. You cannot treat with any doctor you want. You cannot treat with a doctor of your choice. you have to go through a doctor chosen for you by the workman's compensation insurance. Is that correct?
That's absolutely right, Joumana. Unless the insurance company authorizes outside treatment, you're stuck with the company clinic, which for most people means a Concentra clinic that's funded by their employer or their employer's insurance company.
Okay, so the first 28 days, you have to go to one of these doctors um, that are picked out for you by your workman's compensation insurance.
That's right. And as you can imagine, they're not necessarily working in your best interest, but rather in the interest of the company or the insurance company.
And I say quite honestly, whereas there are good doctors everywhere, God-fearing doctors everywhere, conscientious everywhere, I think generally speaking, fair to say that these doctors are not your friend. They are there, they are hired and paid for by the workman's compensation insurance. And the workman's compensation insurance wants you to get off treatment, wants you to go back to work, because if you go back to work, the sooner the better. They will save a lot of money in treatment that they have to pay for you, and you will not be able to have a claim for workman's compensation, because if you are back to work, you cannot, proceed with a case. So a workman's compensation insurance company wants you to treat as little as possible, wants you to go back to work, because they will be paying less money paying your medical bills, and they will be paying less money, processing a workman's compensation claim on your behalf.
Yes, that's right. And the company clinics are often pressured to bring you back to work with some kind of restrictions as soon as possible.
Yes. So the first point I think we want to make today is you are obligated by law the first 28 days after you are in a work-related injury to go through the doctor or doctors chosen for you by your workman's compensation insurance. That's not even your employer. Your employer bought insurance for workman's compensation. The workman's compensation insurance, decides where you go. In car accidents, we don't have that. In car accidents, you can go to any doctor you want, as long as you are within your medical coverage, if that's what's primary. Otherwise, you can go to any doctor you want. So the first 28 days, you have to do that. However, you are not stuck with these doctors after the first 28 days. And by the way, 28 days is continuous days. It's not work days. It doesn't exclude the weekends. It's literally 28 days. So if someone got injured on September 1, 28 days later, they are free to go to any doctor they choose, and that begins on September 29.
That's right. And I've had clients, once the 28 days are up, treat with leading experts in their field. I've had clients go to the Mayo Clinic, for instance, for their work injuries. I've had people go everywhere, and the workers' comp insurance company has to pay for it if it's reasonable and necessary and related to the injury.
اوكي اول نقطه بوصلها انه وقت الانسان بيتعرض لاصابه ضمن العمل، القانون بيقول اول 28 متواصلين بعد حصول الاصابه ضمن العمل، وهن 28 نهار متواصلين، يعني تنين 3 4 5 جمعه سبت احد تنين 3 اتسترا، مضطر انه يلتزم بالدكتور اللي الوركمنز كومبنسيشن انشورنس كومباني بتعين له اياه. بنذكر انه الدكاتره دائما لكل قاعده في استثنائيات، واكيد من وقت الى اخر بيكون في دكتور بيشتغل من قبل الوركمنز كومبنسيشن انشورنس هو ادمي وهو عنده مصداقيه وهو عن جد عم يشتغل من قلبه للمريض مش للانشورنس كومباني. بس كقاعده عامه هؤلاء الاطباء مختارين من قبل الوركمنز كومبنسيشن انشورنس كومباني ومدفوع لهم قبل الوركمنز كومبنسيشن، يعني اللويالتي، يعني انتمائهم لهم اولا واخيرا مع بعض الاكسبشنز للوركمنز انشورنس كومباني. شو بيهمها الوركمنز كومباني؟ بيهمها تختار دكاتره، الضغط على دكاتره، واذا هؤلاء الدكاتره ما تصرفوا طريقة ما بتعود تبعت لهم بزنس. تختار دكاترة يحطوا الضغط على المصاب إنه يرجع على العمل بأسرع طريقة ممكنة، إن رجع مع restrictions ولا رجع بلا restrictions. الهدف هون اختيار الدكاترة إنه يرجعوا المصاب عمل بأسرع طريقة ممكنة. ليه؟ لأنه الورك انشورنس كومباني بتستفيد. كيف بتستفيد؟ كل ما الدكتور اللي هو مختار من قبل الوركمنز كومبنسيشن انشورنس رجع المصاب للعمل، معناتها هذا الإنسان ما رح يتعالج قد ما ممكن يتعالج إذا قاعد بالبيت. يعني بيوفر مصاري مبلغ العلاج على الوركمنز كومبنسيشن انشورنس. وبالإضافة الإنسان اللي بيرجع على العمل ما بيعود عنده القدرة يفتح كليم طالما هو عم يشتغل ضد الوركمنز كومبنسيشن. يعني الوركمنز كومبنسيشن انشورنس بتوفر ميديكال بيلز وقت اللي بتستعمل دكاترة بيحطوا ضغط إنه المصاب يرجع على العمل، أو ما بيعود في كليم. يعني بيوفروا من الناحيتين. يعني كقاعدة عامة هيدول الدكاترة أرناطة. كمان مرة أنا بعرف بعض الدكاترة يشتغلوا مع الوركمنز كومبنسيشن وهن أوادم، بس إذا رح يكونوا كتير أوادم ومع كل العالم أوادم، الانشورنس كومباني الوركمنز كومب انشورنس كومباني ما بتعود تختارهم بالمستقبل، وإنما أول 8 نهار نحن ملتزمين إن شئنا أو أبينا بالدكاترة، مش اللي نحن بنختارهم، مش اللي نحن بنرتاح معهم، مش اللي نحن بنريدهم، مش اللي هن الدكاترة اللي بنريدهم بالاختصاصات المعينة اللي نحن بحاجة إلها، بس بنلتزم بشو الانشورنس دكتور، شو الانشورنس كومباني بتفرض علينا كدكتور. أول ما يمروا 28 نهار تواصل، يعني on day 29، يعني مثل ما قلنا إنسان تعرض لإصابة بسبتمبر 1، بسبتمبر 29 صار عنده الحرية to fire هذا الدكتور اللي هو من قبل الانشورنس، ويختار الدكتور أو الدكاترة اللي بيريدوا. مثل ما قال المحامي بات هوران، بيقدر يروح على الكليفلاند كلينكس، بيقدر يروح على المايو كلينيك، بيقدر يختار أي دكتور بيريده، والوركمنز كومبنسيشن مجبورة تدفع. ثاني شغلة، بما أنه عم نحكي عن اختيار الدكاترة، عن شيء بيسموه نيرس كيس مانجر. خليني أتكلم مع المحادثات بالإنجليزي ونرجع نترجم على العربي. Since we are speaking about, how people are obligated the first 28 days to go to the doctor chosen for them by their workman's insurance company, let's talk about something called case managers or nurse case managers, which you tell me are chosen by workman's compensation insurance company 50% of the time to accompany the injured worker with the doctor's appointments, to talk to the doctors, to are these case managers really our friends, Attorney Patrick Horan, when they are hired and paid for the workman's insurance company?
I make it clear, Joumana, that they are not working for my client. They're working for the insurance company. And therefore, their actions often are going to be in the best interest of the insurance company. Now, these nurse case managers vary widely in how above board they are and how good they are. But at the end of the day, they're trying to get you back to work quicker and make your treatment less expensive for the insurance company. That's what they're trying to do.
So what you are telling me, Attorney Patrick Horan, is that just like the doctors chosen by the workman, the nurse case managers are also chosen by the workman's insurance to, in essence, do whatever the case manager can do in talking to the doctor, also chosen, at least in the first 28 days, by the insurance company to get the injured worker back to work as quickly as possible.
Right. And there's, you still have privacy rights with your doctor. And I instruct my clients that this nurse case manager, if they're going to accompany you to a doctor's visit, they do not get to talk to the doctor without you present. Okay? And tell your doctor up front that you don't want them in the room without you there to hear what's being said.
So you advise, we talked, Pat, about firing the case manager who was hired for you by the insurance company and replacing that case manager with one you choose. And you said it can go both ways. because if you do that and the workman's comp insurance company was paying for the person, it might become acrimonious. They may decide to stop paying. The insurance company may get irritated with that, although a client or an injured worker is totally in his right or her right to do that. So you called it kicking a hornet's nest, in essence, correct?
That's right, Joumana. We talked about that turn of phrase that I used. But there's never going to be a nurse case manager assigned to a case that is in dispute. It's always going to be a case that's not in dispute where there's a nurse case manager going. If the case is in dispute, of course, no treatment is authorized. And if you're getting treatment, you're paying for it yourself or using your own health insurance for treatment. But for a case that's not in dispute, the insurance company could try to send that person there. And if I call up a claims adjuster and say, I don't want that person to handle this case anymore, well, that might cause them to find a way to dispute the case quicker. So I'm not going to necessarily fight that fight and cause my client's benefits to get cut off quicker.
Okay, so this is a strategy you use, and although you can totally fire the case manager and replace that case manager with someone chosen by you, someone you trust, someone who is more accountable to the injured worker than to the insurance company who hired the case manager in the first place, you may decide not to do that simply because it may stop benefits or it may delay benefits. But if the workman's compensation insurance company has already stopped paying and it's already in dispute, you may be more likely to replace that case manager with somebody else.
Right. And I mean, let's face it. Do you have a nurse case manager when you go see your doctor? No, we don't need a nurse case manager ourselves. The only reason that person is there is because the insurance company wants to be in the room when decisions are being made about treatment.
So I think one of the pieces of advice that you've given today is, like you said, there are HIPAA rights. Patients have the right not to have medical information disclosed about them without their permission or their absence. So you're saying very good advice. You're saying that if someone has a case manager in a work-related injury appointed by the workman's compensation insurance, they should come out and say to the doctor in front of the case manager, "Doctor, I don't want you to discuss my case with the case manager in my absence or without my." And this way, you cut the primary reason for why the case manager was hired by the insurance company, which is to dictate to the doctor what he should or should not do. And the bottom line is, as little treatment as possible and quickly back to work as possible.
That's right.
Okay. So كمان الانشورنس كومباني 50% من الأوقات الوركمنز كومبنسيشن انشورنس كومباني بيختاروا للمصاب شخص أو سيدة بيسموها كيس مانجر أو نيرس كيس مانجر. هيدي الكيس مانجر كمان منا صديقنا. الانشورنس كومباني معينتها وبتدفع لها بسيط لتروح مع المصاب عند الدكاترة ولتحاول تقنع الدكاترة إنه هذا الإنسان منه مصاب ولازم يرجع على العمل بأسرع طريقة ممكنة. طبعاً we can fire الكيس مانجر. بيقول المحامي باتريك هوران أوقات it's not a good idea إذا كانوا عم يدفعوا طبياً لأنه يمكن تعرقل الأمور وتوقف الدفع. بهيدي الحالة نطلب من المصاب إنه يتكلم مع الدكتور، إنه كل إنسان عنده HIPAA privacy rights بالمعلومات الطبية تبعه. كل إنسان بحق له إنه يطلب من الدكتور تبعه إنه ما يسمح بأي معلومات طبية توصل لأي إنسان إن كان خيه بيه جوزه بنته أو كيس مانجر بلا العلم منه أو بلا وجوده. فهون بنقول لإنسان مصاب عنده كيس مانجر معينة من قبل الوركمنز كومبنسيشن انشورنس كومباني إنه يبلغ الدكتور بوجود كيس مانجر، يا دكتور ما بسمح تتكلم عن الملف مع الكيس مانجر بلا ما أكون أنا موجود بالأوضة وبلا السماح مني. يعني ما بيقدروا يحكوا على التليفون وما بتقدر تروح تشوفوا قبل الموعد أو بعد الموعد، المفروض يكون موجود كل الوقت. إذا كان الكيس in dispute، إذا كان الكيس already الانشورنس كومباني workman's comp مش عم تدفع، ساعتها سهل علينا إنه نفاير الكيس مانجر اللي هي معينة من قبل الوركمنز كومب ونعين وحدة من يمنا نحن، يعني اللويالتي تبعها هي للأصحاب. رامي إذا ممكن ناخذ وقفة سريعة ومنكمل هذا الموضوع.
نعم شو. مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات قبل أن تختار المحامي الذي سيدافع عن قضيتك. دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج Your Rights مع المحامية جومانا كيروز. أرقام الهواتف في الاستوديو 313-769-6666 ومن وينزر كندا 519-256-1023 وعلى الواتساب 313-327-7074. جمانة رجع لك؟
نعم أنا بعتذر بعد عندي خشخشة، بس حاولت أكثر من 5-6 أماكن بقلب المكتب وما في تغيير بالموضوع. يمكن أنا وياك لازم نبحث بهذا الموضوع رامي بعد الشو لحتى moving forward نكون شوي الأوديو أحسن هيك.
إن شاء الله.
Apologize. I am aware that I am creating a lot of static. I moved 5-6 different places inside the office, no luck. So Rami and I will try to figure out a better solution moving forward.
Inshallah, sure.
I apologize. Going back to, we're talking about workman's compensation. Sometimes a doctor, typically the workman's comp insurance doctor, but not always, Pat, will tell the injured worker, yes, you can go back to work on light duty.
That's right. Very common.
Okay. Before I continue with that question, and what should an injured worker do or not do, and what are the consequences, we have a caller and we talk about workman's compensation. Hello?
Hello.
يا أهلا وسهلا.
يعطيك العافية. My name is Leo. I have a question regarding, I had an accident about 2 years ago, semi-truck accident, and I had a knee injury. I had a lawyer. Then I went to the doctor. The doctor did a meniscus surgery on my left knee.
Mr. Leo, is that a work-related accident or just an accident?
Semi-truck work-related accident.
Okay, let me ask you a question very quickly. Were you a 1099 driving the truck, or were you an employee driving the truck?
1099. I was a 1099.
Well, then this is not a workman's compensation. Am I correct, Attorney Pat Horan?
Well, we talked about that in an earlier episode here. In some cases, even though you're getting paid 1099, you still qualify as an employee for purposes of workers' comp. So,
really?
Yeah. Every case is different. But
that's true.
Leo, did you say that your case was run through workers' comp?
Yes, it went through workers' comp. Everything was fine. And after 6 months of my surgery, I did not get paid. So I was forced to go back to work because there is no income coming to me. And my lawyers kept telling me everything is going to be fine, but, you have to do whatever you have to do. So I told my doctor that I do need to go back to work because I could not make it.
Right.
So the doctor gave me a release that I can go back to work. I went back to work for 2 months. I could not do it because of my injury. My injury started to get worse. So I went back to the doctor. The doctor told me, you have another tear in my meniscus.
This is a perfect example, Leo, of what we were going to talk about today. So you did the right thing when your doctor said you could go back to work to try to do the job. And then when you tried it, it made you worse, didn't it?
It did make me worse, but the issue is my lawyer would not. He said, no, the second injury, I cannot prove it in court that it happened from the first injury because your doctor say, no, it just happened. And between me and you, That's not true. The same day I went back to work, I was in pain, and I kept calling the doctor back and telling him, "Listen, doctor, this is, my knee is buckling. I'm having issues and stuff like that." So when he did, after the second pain really bad, I went back to him. He sent me to do an MRI. It showed another tear. So my lawyer is saying that the second injury is from the second job, and I don't see that. You follow what I'm saying?
Well, I mean, that's going to come down to the medical. If you had an MRI that did not show a tear, you went back to a second job and now it shows a tear, then I would probably agree the second job caused that new tear on the MRI.
But I was complaining from day one of the same pain.
I understand. Now, as a practical matter, and I'm not going to step on your attorney's toes, but as a practical matter, it might be good strategy to blame it on the new injury, because then you can settle out against the old employer and pursue the new case. You follow me?
Yes.
So that could be what's going on here, but without having the benefit of all the information your attorney has, I can't answer that.
Yeah, you can only answer generally, Pat, because it's going to be very case specific, the testing,
Right.
what he told the doctors, when, and so forth.
Right.
I had to go back to work because there was no income coming to me, so I needed to go back to work.
Leo,
This
I
is how the
totally
insurance
understand.
company pushes you. They don't pay you until, they want you to go back to work. They push
Well,
you
of
to go back to work.
Because if you go back to work, then they don't have to pay you and you don't have a claim. And the next thing we were going to talk about is that you have no choice. You have to go back to work, because they tell you that you need to go back and you don't, they will use it against you, and a judge may use it against you as well.
So your advice to me is not to go after the first company for the second injury?
Right. In workers' comp, Leo, generally the last employer is stuck with the injury. So, in a situation where you've worked 5 different jobs and, for instance, you hurt your back and it keeps getting worse and worse and worse, it's that last employer that's going to get stuck under workers' comp law.
No, okay. I got you.
Okay?
Okay, sir. Joumana,
Thanks
thank
for
you very
calling.
much. I came to your office and I met with you about 2 years ago, but for some reason you told me, it wasn't a solid, but now everything is going through, thank God. I wish you would have, I like you a lot, and I wish we would have been client and lawyer. That's fine, but I still love you.
Thank you.
Thank you, Leo. I wish you the very
Okay,
best.
thank
And
you very much. God
Leo,
bless.
and the listeners, one can only judge a case with the information we have at the time. Maybe 2 years ago, there was nothing. Maybe 2 years ago, they were paying you voluntarily. So Pat would say, there is nothing for me to do. So the dynamic changes all the time. Surgery, going back to work, that changes everything, no question.
That's true.
Leo was about the fact that the insurance company, the workman's compensation insurance company, told him he needed to go back to work, and he had no choice. He needed to, because he needed to live. They weren't paying him. Well, insurance companies generally, whether they are insurance companies or workman's compensation, they don't pay you on purpose. It is a strategy designed to put pressure on you, financial pressure, to go back to work. And a lot of people give in to that pressure, understandably, because they have bills to pay. The one thing we want to add here, and that was the next point we were making, is if a doctor, whether it is a Concentra doctor, a doctor hired by the workman's compensation, or your own doctor, if a doctor tells you you need to go back to work, maybe put you on light duty, maybe you used to lift 50 pounds before and now you can lift 10 pounds, then you have a duty to go back to work. Because if you don't, you will be punished. Can you talk about that, Patrick?
Yes, Joumana. There's 2 different possibilities here. One is that your employer, where you got hurt, offers you that light duty job. You're using 10-pound lifting. That's a great example. So they offer you a light duty job where you only have to lift 10 pounds. You have to go back and try that. And if you don't try it, you're probably not going to be able to win your workers' compensation case. It's as simple as that. Now, the other possibility is that you have restrictions of 10 pounds and your employer doesn't have a job like that. Well, you still have to try to find work within that restriction. And my advice to people is that they register with Michigan Works in Lansing and show that they've applied for 3 light-duty jobs a week while the case is in dispute, so that they can show a judge, I'm looking for work within my restrictions, but I can't find a job.
Okay, that's all mitigating your damages.
Exactly.
Okay, so let me break that down. If a doctor says you can go back to work on light duty, less hours than you used to put in, or with certain restrictions, you don't have an option. You have to go back to work. Where do you go back to work? If your past employer, the one you just got injured from, has a position that fits your new restrictions, you have to go back to that job. At least try. If it works, it works. If it makes your medical condition worse, then you can get off work, but at least you would have shown in good faith that you tried to go back to work and you just couldn't make it.
That's correct.
Your employer does not have a job for you that fits your new restriction. Then Attorney Patrick Horan is saying, and his advice to clients is, apply to 3 jobs, at least 3 jobs a week. Apply to at least 3 jobs a week. Register at Michigan Works. Send in your resume, and there will be a lot of jobs there. Now, of course, it is okay, and it even makes sense that when you call prospective employers, you have to tell them you're injured. You have to tell them what your restrictions are. Chances are, once a prospective employer hears you say you are injured, you are on restriction, chances are that employer does not want to take you. But at least you will have proven that you are trying to find a job, only you can't find one. So you apply to at least 3 different jobs a week to show that you're doing everything you can to mitigate your damages. Because if a doctor says to you, you can go back to work light duty, and you don't make an attempt to go back to your current employer or somebody else, then a judge in your case may hold that against you and say, we're going to deem as if you found a light duty job at so many dollars an hour, and it's going to reduce your workman's compensation settlement by so many dollars. Correct?
That's right, Joumana.
Okay. But we know practically once you disclose to someone that you are injured and that you are on restrictions, we know that practically you are not going to be hired. Now, let's say somebody who has been told he can go back to work, light duty. Let's say that person used to make $1,000 in the job, but the light duty job, whether with the employer they have or somebody else, pays, let's say, $600. $600. They used to make $1,000, but this is a much easier job. They now make $600. So they are $400 short because of their injury. Will the workman's compensation give them back that $400 and put them back in the situation they would have been in had they not been injured, which is $1,000? We're talking about a $400.
Workers' compensation will make up 80% of the difference.
So that will be $320.
Yes, and I got on my calculator because you changed the numbers that we did before we were on the show.
500 was too easy. So they will get 600 from their employer, and they will get 300 from their 320 from workman's comp. So they will make $920, which is less than the $1,000.
Well, yes, but the 320 is an after-tax figure. Workers' comp benefits are always after-tax, so you're going to essentially be made whole because you're not paying taxes on that additional money.
So when you go to file your taxes, you are filing your taxes on the $600, not on the $320. That's why they pay you 80%. They take out the taxes.
That's right.
That's a new thing that I did not know. Thank you very much for clarifying that. So, like the gentleman who just called us and said, he said, in essence, they forced me to go back to work because I have to make a living. But quite sometimes a doctor, typically an insurance doctor, but not always, will force you to go back to work on light duty and you have no option. You have to go back if your employer has such a position. If not, you have to what we call mitigate your damages. This is exactly like in a landlord-tenant situation. If a tenant leaves the premises, even though there is a contract, the landlord can't sit and say, I'm not worried, I'm going to court and I'm going to recover the difference. A landlord has a duty to mitigate his damages and try to find a new tenant. And that concept of mitigating damages, we see that in several areas of the law.
That's right.
And by the way, if you go back on light duty, you may get worse. So it's okay to get off work again. In fact, it will make your case stronger if you tried and you couldn't work.
Right. And I always give people the advice that if they do go back and their pain level goes higher, to immediately report that to their doctor so there's a record that it made it worse.
And that's very important. And we know that the gentleman who called us on his first day back from work after surgery, he was calling his doctor and saying, I'm really hurting. That's very good. That's a good track, letting them know that you're getting worse now that you went back to work.
Yes.
So before we take a break, I want to ask you a question. I understand why workers' compensation insurance companies want people to go back to work because as quickly as possible, because they will save money on treatment, because somebody who's busy working is going to treat less or stop treating. And number two, then there will not be a claim for workers' compensation because they are working. Why is it that sometimes we find employers want to bring back employees, even those that are already, so to speak, damaged goods and are already injured and they are on restrictions? Why? What is it for the employer? If I were an employer, I would want somebody who is not a liability to me, who is feeling good and is not injured and, can give 100%.
Right. Well, there's two things going on there. Number one, the employer might be pressured by their insurance company because of the particular policy of workers' comp insurance that they bought to aggressively bring people back to work. And the other thing, it's sad and I think true, is that sometimes they'll bring people back to a demeaning position in order to pressure them to drop their case.
Okay, very good. So let me quickly translate this into Arabic, and then we're going to take a quick break, catch our breath, and we're going to be talking a little bit about social security after the break. So كنا عم نقول وقت اللي دكتور بيقول للطبيب إنه لازم يرجع على العمل حتى لو كان on light duty، حتى لو كان ساعاته أقل أو المهمات تبعه أقل، من الضروري جدا إنه المصاب يتبع إرشاد الدكتور قانونيا. عم نحكي ليه؟ لأنه إذا ما تبع إرشاد الدكتور يمكن القاضي بالملف يقول له بعدين أنت ما تبعت إرشاد الدكتور، ولو تبعت إرشاد الدكتور كنت لقيت عمل أو كنت رجعت عند رب العمل تبعك بمهمة أخرى وكنت طلعت هالقد مصاري، فنحن رح نحسب كأنك أنت طلعتها ورح نقسم لك إياها من التسوية تبعك بالنهاية. ضروري جدا إنه الإنسان المصاب إذا الدكتور إن كان دكتور الإنشورنس أو دكتور الخاص بيعطيه back to work life duty، ضروري جدا على الأقل يفرجي إنه حاول. إذا حاول ورجع وما قدر، على القليلة الكيس تبعه صار لأنه بيفرجي إنه حاول وما قدر. ومن الضروري جدا إنه يبلغ الدكتور تبعه إنه حاول وما قدر، مثل ما الشخص اللي اتصل فينا الأستاذ ليون اللي قالنا إنه أول نهار بعد ما رجع من العملية تبعه ما حاسس حاله منيح، ومن البداية اتصل بالدكتور تبعه وبلغه. يمكن كتير أوقات وقت الدكتور بيرجع المصاب رب العمل ما عنده job description مثل اللي هلأ الدكتور عم بيقول إنه هيدا الإنسان مؤهل إلها. يعني هيدا الموظف كان يشتغل يعمل ليفتنج 50 باوند، يمكن هلأ صار فيه يعمل ليفتنج فقط 10 باوند، يمكن رب العمل ما عنده بوزيشن ليفتنج بس 10 باوند. ساعتها المسؤولية بتوقع على المصاب اللي في دكتور قال له بده يرجع on light duty إنه يحاول يلاقي شغل. والنصيحة اللي بيعطيها المحامي باتريك هوران لكل المصابين واللي انطلب منهم يرجعوا على العمل، انه على القليلة يبرهنوا انه قدموا على مينيموم 3 jobs per week. 3 jobs per week يعني 12 ل 15 job per month. هين كتير. بيقدر الإنسان يعمل registration مع ميشيغان، يبعت الريزومي تبعه أو السي في تبعه، وفي كتير job postings. و it is totally okay إنه المصاب اللي عم بيحاول ينبه على شغل light duty وقت اللي بيتكلم مع رب عمل يمكن يكون عنده position، it's okay إنه أنا مصاب، أنا عندي light duty، أنا هيدي إصاباتي. نعرف عمليا إنه أي رب عمل له الشخص اللي مقبيله إنه هو مصاب وإنه هو على لايت ديوري بحق له رب العمل يرفضه. ما قلنا غير بس نبرهن إنه نحن حاولنا ننبش على الجوبز حتى لو ما لقينا، لأنه في شيء بالقانون اسمه واجبات كل إنسان to mitigate her or his damages. واجبات كل إنسان إنه يخفف من وطئة الإصابة المادية. هيدا الإنسان اللي في دكتور قال له فيك ترجع لايت ديوري، إذا الرب العمل تبعه ما عنده بوزيشن له، بيحاول ما لقى يعني بيكون هيدا الإنسان عمل أقصى جهده to mitigate his damages. ضروري جدا إنه الإنسان اللي بينعطى رشدته يرجع على العمل يحاول رب العمل تبعه بالأول، إذا ما عنده بوزيشن بيحاول to apply. عمليا أي رب عمل جديد رح يسمع إنه الشخص اللي عم بيقدم على بوزيشن مصاب وعنده ريستريكشن مش رح يقبله. هون بنكون برهنا إنه قدمنا على القليلة على 3 jobs per week، وهذا الشيء لا يستعمل. رح ناخد وقفة سريعة وبننتقل لموضوع disability for children، بشغلة بدنا نوضحها.
هل أنت بحاجة للمساعدة في جلب شريك الحياة إلى الولايات المتحدة؟ بالرغم من أن إجراءات الهجرة على أساس الزواج معقدة للغاية، إلا أن محامي الهجرة من مكاتب المحامية جومانا كيروز تمكنوا بنجاح كبير مساعدة آلاف الأشخاص للهجرة إلى أمريكا، لأن لديهم الخبرة الطويلة في مساعدة الأشخاص على الحصول على الجرين كارد على أساس الزواج أو فيز الخطوبة بشكل سريع ومريح بقدر المستطاع. اتصل الآن بمكاتب المحامية جومانا كيروز 1866 Your Rights 248-557-3645. Your Rights مع المحامية جومانا كيروز.
وبنرجع مثل كل نهار خميس لمدة ساعة من الساعة 1 ل2 مع المحامي هوران، اختصاصي في قضايا الضمان الاجتماعي ISP Survivor Loss إلى آخره، واختصاصي في الإصابات ضمن العمل Workman's Compensation. قبل لا انتقل عن Disabled Child Case بدي أفهم منه أكثر ليه الأستاذ ليو اللي بنشكره اتصاله، لأنه اتصاله لخص كثير من النقاط اللي نحن اليوم بدنا نحكي عنها، اللي هي الرجوع إلى العمل إلى آخره. بدي أفهم من المحامي باتريك هوران ليه مع أنه الأستاذ ليو اللي كان عم بيسوق سماي تراك وهو independent contractor قدر قدم ونجح عبر الوركمنز كومبنسيشن، لأنه أنا بصراحة ضعت بهذا الموضوع. Attorney Patrick Horan, I know you mentioned it before and you just said that Leo, who is an independent contractor, it seems he was qualified to apply for workman's compensation. Can you tell me why? I thought the law is very, very clear. If you are an independent contractor, truly an independent contractor, not act like one and quack like one, but really one, and we talked about the 20-factor rule, that rules that the IRS use to show who's really an independent contractor versus who is really an employee. But is that what you are hinting at, that maybe Leo was really an employee presenting as an independent contractor? Or what is it that why is it that he was an independent contractor who's entitled to workman's compensation?
Right. Well, what Leo said just now on the phone call is that he was paid on a 1099. We didn't get into any of the other factors that you and I have discussed on this radio show about which would qualify him to be an employee under the Workers' Compensation Act. So even though he was paid 1099, it seems likely that his case was handled under workers' comp because his employer handled his scheduling, could hire and fire him, all the other factors we talked about in the past.
Okay, so we're not deviating from that rule, is that it doesn't matter what you call someone, a 1099 or an employee, there are things, mostly control, that point to whether this person is truly a 1099 or not. So we conclude here, we are inferring from Leo that chances are he was really an employee who called himself, or who his employer called him, an independent contractor. But it seems like somebody did the analysis, his lawyer, and decided he is really an employee, although he called himself or his employer called him an independent contractor. So that's why. That's the only time someone would qualify for workman's compensation.
That's right.
Okay. And very quickly, we're talking about the ability of someone to control you points to the fact that you're really an employee, no matter what you are calling yourself. So نحكي بالعربي بطريقة سريعة. الأستاذ ليو قال هو independent contractor وعنده 1099، بس بالحديث خبرنا إنه عم يحصل workman's compensation. القاعدة بتقول إنه الإنسان الاندبندنت كونتراكتور ما عنده workman's compensation. الworkman's compensation الانشورنس تبعها، الطبابة، تغطية الراتب، هيدول كلهم بس للإنسان اللي هو موظف. عم وضح مع المحامي باتريك هوران، نحن بنستنتج من المعلومات اللي اعطانا اياها الاستاذ ليو انه هو مفكر حاله 1099، او يمكن رب العمل ليوفر عليه ضريبه مفكر حاله كاتبه 1099، بس اذا قدر حصل على وركمنز كومب يعني للحقيقه الاستاذ ليو هو منه 1099، هو امبلوي. وكيف نعرف الفرق بين إنسان 1099 وإنسان إمبلويي بغض النظر شو الإنسان مفكر حاله أو مسمى حاله؟ إذا إنسان عنده القدرة يسيطر على إنسان تاني، يتحكم بالجدول تبعه بتعليم كتيرة، هيدا بتعني إنه العلاقة بين الاثنين هي علاقة employer-employee، هي منا علاقة independent contractor. So حكينا عن هيدول الماضي، بنرجع بنحكي عنهم بالمستقبل. حتى ال IRS for tax purposes بهمها كتير تفصل مين عن جد independent contractor بغض النظر شو مفكر حاله أو مسمى حاله، ومين عن جد هو W2 بغض النظر شو مفكر حاله أو مسمى حاله. لأنه في قصة دفع FICA taxes، نصها للإمبلويي نصها للإمبلوير إذا كان الإنسان عن جد موظف. في 100% of the FICA taxes 15.3% بتندفع من قبل independent contractor إذا كان جد independent contractor. So حتى ال IRS عاطيه 20 نقطة ولا وحدة منهم is this positive، ولا وحدة منهم هي وحدة كافية لحتى الإنسان يستنتج إذا الشخص اللي مسمى حاله independent contractor هو عن جد independent contractor. بس خلاصة الأمر وأهم نقطة من كل هول هي إذا إنسان ما قادر يتصرف بالشغل تبعه مثل ما كل ما يكون عليه كنترول أكتر، كل ما يكون عليه conditions أكتر، كل ما يكون عليه شروط أكتر، كل ما هيدا الإنسان إن شاء أو أبا هو بعلاقة employer-employee. Thank you, Attorney Patrick Horan, for bringing that clarification again to the fore. Let's move on with the 8 minutes remaining. Child disability, SSI. Again, for a child to qualify for disability, it is a means test, meaning that the parents, not only should the child have a disability that qualifies him or her for the qualifying disability, but also the parents should the means, the financial means of the parents should also qualify, right?
That's right.
Can a child obtain SSD if the parents' income is more than humble?
No, there is no child's disability benefit for wealthy children.
Okay, so there is no SSD for children. There is only SSI for children.
Right.
One of the points that we want to bring up is it was brought on by a couple of our. Go ahead. You wanted to say something, Pat?
No, I was waiting.
Okay, I apologize. One of the points that we wanted to talk about today very quickly is parents, please be very, very transparent with the Social Security Administration on how much money you make when you apply for the child SSI, and continue to update the SSA, the Social Security Administration, if you make more, because sooner or later, the Social Security Administration is going to find out you're making more or you started making more. And you have two options. either you tell them or you will be hit with an overpayment that you have to pay back.
That's right, and it's a pretty scary thing to get a letter from the government that says you owe $18,000 for past due benefits.
When you get a letter like that, can you negotiate a payment plan?
Yeah, very often, especially if you have limited means and you can show it was not through fraud or was not your fault that the overpayment occurred. They generally will take a case where there's continuing disability and negotiate a fairly small monthly reduction in the payment to pay off that overpayment.
اوكي ثانك يو فيري ماتش. سو اول نقطه بنوصلها بموضوع السوشيال سيكيورتي الضمان الاجتماعي للاطفال، ضروري جدا الاهل مش بس يبلغوا بالبدايه، لانه ما في شيء اسمه اس اس دي للاطفال، هو SSI، واي انسان بيحصل على SSI ان كان طفل او ان كان فوق السن بده يفرجي انه مدخول البيت والريسورسز تبع البيت هي متواضعه جدا. بحال الطفل مش بس بدنا نفرجي انه عنده ايصال، بدنا نفرجي كمان انه الحاله الماديه تبع الاهل متواضعه جدا. اذا هيدي الظروف تغيرت وتحسنت ظروف الاهل ماديا، من الضروري جدا الانسان الاب او الام يبلغوا السوشيال سيكيورتي ادمنستريشن، لانه احتمال كتير كبير انه السوشيال سيكيورتي ادمنستريشن تكتشف منها لحالها انه الانكم في هذه العائله عالي، ويبعثوا له رساله للاب او للام انه في اوفر بيمنت $18,000. يعني احسن نبلغ انه علي المدخول تبعنا وينزل المبلغ الشهري لطفلنا، ينزل $1 او $10 او $100، من انه نطنش عن الموضوع يكتشفوا منهم لحالهم ويبعثوا لنا رساله انه you have an $18,000 or $5,000 overpayment that you have to pay back. So ما في مهرب منها، مش بس المعلومات لازم تكون صحيحة نهار اللي منقدم للطفل على SSI، بس every other point after that. النقطة الثانية اللي بدنا نحكي عنها للإنسان اللي بده يقدم على SSI يكون كتير واضح مع الدكتور تبعه إنه exactly she or he is disabled. Can we talk about this, the 3 minutes remaining, Pat? When you apply for SSI, very important that you have your doctor spell out exactly how you are disabled. It's not enough that the doctor writes that you are totally disabled.
That's absolutely right. And if a doctor presents that letter to Social Security, the Social Security Administration will simply respond, the question of disability is not for the doctor, it's for us to decide. So what the doctor needs to do is to spell out what functional limitations the patient has that would prevent them from performing any work.
So
we've got a questionnaire we use.
Okay, so if someone is disabled, is a legal determination for the Social Security disability, is for the government, not for the doctor. So even if the doctor writes somebody's disabled, that is not enough. The doctor, rather, should spell out all the different ways someone is disabled. For example, the doctor should write that his patient cannot sit, cannot stand for more than a minute, cannot lift, etc., 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 etc. Is that correct?
That's right. Those are the specific functional limitations which would interfere with somebody performing a job.
Okay. And it's not for the doctor to say, my patient is disabled. Even if the doctor says that, the Social Security is not going to rely on that. The Social Security is the one that will determine if someone is disabled after the doctor writes out in a zillion different ways all the various things the patient can or cannot do or cannot do as much anymore, and the Social Security Administration will reach that conclusion.
That's right.
It's my understanding that you send out a questionnaire to our clients' doctors to fill out that spells out many, many different ways how someone is disabled: sitting, standing, lifting, bending, and so forth, right? Walking.
Yeah, and a lot of people don't think about the things that interfere with the ability to work. Several physical conditions require you to elevate your legs in front of you, and Social Security will agree that there's no jobs available that allow you to elevate your legs out in front of you.
So What we encourage is that doctors who receive that questionnaire, that they take the time to fill it out. That's the best way you can help your patient.
That's right.
All right. Well, our time is over. Thank you very much for the very valuable information at Patrick Horan, both in workmen's compensation as well as in social security. And God willing, we will talk next Tuesday. رامي شكرا جزيلا. ولبكرة إن الله راد مع المحامية ماريا بانشينكو بموضوع الفاميلي لا واللا.
شكرا جمانة، تحياتنا لك ونشكر لكل مستمعينا حسن المتابعة. إلى اللقاء.